Well, hi there. If anyone's still out there being ever so very patient, you're not supposed to begin these things with an apology, but Sheldon and I struggled mightily over technical things lately, so we might have a bit of a shortened hour that is not an hour. However, as you well know, if you're watching this, this is Liberty.me live, in spite of all that, and this is also free association. I'm still Lucy Steigerwald, and that is still Sheldon Richman, and you still know us from various fine websites and publications and this lovely podcast. And without further ado, because the hour runs late, Sheldon will start us off with the topic of the fortnight.
Hello. We thought we would cover several topics which are related. Since there's not that much new in the presidential campaign, actually, just when you thought the presidential campaign was running out of steam, Antonin Scalia goes ups and dies on us. I guess he thought the campaign was just too boring, and that the only best thing he could think of was to leave the scene. It occurred to me the other day. I don't mean to make fun of a man dying because I don't believe in doing that, but. And we could talk about him. He's an interesting person. But it occurred to me that the morning after he left us, I imagine it was maybe a rare day when the conservatives woke up and cursed him, and the progressives woke up and blessed him. Because, you know why? Because he left. And he was considered the quintessential conservative on the Supreme Court. So let's talk a little bit about him and then how it relates to the campaign and, with the Senate saying they're not going to entertain any nominee, and Obama claiming saying he will nominate someone. Anyway, so a little bit about Scalia, who I had occasion to write about back when the Obergefell ruling came down, which was the same-sex marriage ruling. As usual, when he's in the losing side, Scalia issued a very challenging, provocative dissent. I mean, he was always challenging and provocative. Say what you want about the guy. He was a very smart guy and sharp and a good writer, and people respected him. All across the spectrum. We can make particular libertarian criticisms of him, which I'm sure will come up. But to say a little bit about his views, I once. Back when I worked for the Cato Institute in the mid-'90s, he came to a private staff lunch, off-the-record lunch. I assume now that he's gone, the off-the-record doesn't bind me anymore. Besides, I don't think he said anything he wouldn't say in public. He was a rather outspoken person. He gave lectures in a lot of places and said stuff. So I'm not betraying any confidences here, telling tales out of school. But the two lines that he spoke that day, and it was very small. It was maybe 10 people. It was the senior staff. It was not a public. We did this with a lot of people. So the two lines that he spoke that day have stayed with me ever since. So we're going back to 94, 95. It's been a while, right? That's over 20 years. He said his job is not to strike down laws that are unconstitutional. His job is to strike down laws that are really unconstitutional. And that's a verbatim quote. You can interpret that as you like, but he said that. Then the other thing he said was that the Cato view of the Constitution and the Supreme Court, role of the Supreme Court, would, quote, bring down the Republic. So that means I need to say a little bit about the Cato, quote, the Cato view. By that he was referring, I think, mainly to stuff that Cato published a lot by Richard Epstein, by Randy Barnett, by Roger Pilon, but I think he was thinking primarily of Epstein and Barnett, and also they had published a book when Robert Bork was nominated around that time. Bork was nominated after Scalia, so but I think the Bork thing might have happened by then. I guess the timeline's a little fuzzy for me. But anyway, this view that he thought was going to bring down the Republic had gone by the name of principled judicial activism. This is where our side, and I think it's generally right, embraced the idea of judges protecting freedom, actively protecting freedom. He thought that was also relying on the Ninth Amendment, of course, which says that there are unenumerated rights, right? The rights that are listed here is not an exhaustive list. That's my translation of what the Ninth Amendment says. So he thought that was horrible. He thought that would just, open the floodgates for judges finding rights, inventing rights, and he thought that would be terrible. He didn't seem to be so worried by judges inventing or legislatures inventing powers or reading powers into the rest of the Constitution. So this view of his is a very I would call it a limited majoritarian view. The idea is that unless an act of Congress or an act of a legislature directly and egregiously, and that's what I think when he said really unconstitutional, egregiously violates one of the rights specified in the Bill of Rights, or violates one of the prohibitions in the Constitution. There are certain prohibitions in the Constitution on what the Congress can do. So unless it's one of those things, and he's very strict about this, the job of the court is to defer to the democratic branches, specifically the legislature. And that they should, activism is bad because it interferes with the legislature, which he interprets as the people's representatives, and therefore the people's right of self-government. Now, I think this is a philosophy that libertarians can blow holes in, but that was his view, and he thought this Ninth Amendment-oriented judicial activism that Cato seemed to that it did favor would destroy the republic. I mean, he used a term like that. I believe he said, "Bring down the republic." So that gives you a clue to Scalia's approach. We could talk more about it. The other thing I want to mention is the word originalism, because he's regarded as an originalist, and there are a couple different variations of originalism. There's original intent. There's original meaning. He's an original meaning guy. He's a textualist. He thinks you need to read the language and interpret it on the basis of what those words meant to the people at the time. Not the framers, not the people at the Constitutional Convention, at the Federal Convention in Philadelphia, not the ratifiers, but I guess he'd say the plain meaning of what was generally understood by those words, which is another thing we can attack. But I guess I'll stop there and let you get in. I think I probably said enough to stimulate some discussion.
Well, I confess I didn't know as much about him. I think the Supreme Court, I know my relevant cases, I can cite and complain about certain ones, but I looked up Scalia because I wrote a thing about him for Playboy, and Jacob Solomon at Reason helped with that because he had a great piece that I worked off of, where I talked about how Scalia was surprisingly decent on the Fourth Amendment, certainly not as what we would prefer, but much better than you would expect a guy who's, a right-wing, scary monster guy to. He was better on it than you would expect. I don't know. I mean, there's so much subjectivity in this, in just all of the things you just said with originalism, and yet the Ninth Amendment apparently he can't be bothered with that, which to me just directly conflicts with this idea that he may think it's a less important amendment, but it's sitting right there with the rest of them. I mean,
well, he took Bork's view, and Bork famously said that the Ninth Amendment, he doesn't know what the Ninth Amendment means. It's as if an ink blot obscured the text.
Right.
That's what Bork says. And Scalia, I don't know if Scalia would endorse that exact formulation, but Scalia is regarded as, an ideological brother or jurisprudential brother of Bork.
I found an interview, it was actually a casual interview with New York Times Magazine or something from a couple of years ago, where he references that, and he basically seems to agree. And I guess the problem with the Ninth Amendment problem is that it sounds like, the negative liberty loophole, and I think therefore it behooves certain people to dismiss it because you could build a delightfully negative rights foundation on it. But also, I assume the fact that there's not much precedent for people like Scalia to build upon, I guess. I assume is part of it, because what's the precedent? You have more rights than it says specifically that you do? I mean, I don't know.
Well, right, and of course, look, they were aware of the history of the Ninth Amendment, right? When there was a call for a Bill of Rights, some people said, including Federalists who wanted the Constitution to just stay as it is, they didn't want to tamper with it or add anything to it, they said, if you put in I think Madison actually says this specifically, if you put in a list of rights, that's going to be construed as an exhaustive list.
Right.
So somebody, I'm not sure actually who came up with this, said, okay, I got a cure for that. You put in an amendment that says this is not an exhaustive list.
Right.
So they did. The fact is, it's interesting that the Bill of Rights, of course, the Bill of Rights really didn't kick in until the 20th century. You know, after all that time, from 1789 onward, they did not figure in court decisions until we get into the 20th century. But the Ninth Amendment has really never figured in. I believe it's in a dissent, or maybe a concurring opinion, I forget now, by Arthur Goldberg. He mentions it. But it's never decided a case, right? No majority has ever said, we're striking down this law that violates this right, and even though this right is not specified in the first 10 amendments, the Ninth Amendment says we can do it, that it is a right. There are other rights, and so therefore, that's never happened.
I assumed it was practically never. I wasn't sure if it was truly never, but I'm not terribly surprised.
Unless something has happened since the Goldberg. I mean, for a long time, I know people would say Goldberg mentions it in, like I said, in either a concurrence or a dissent, so it didn't control. Now, maybe it's been cited after that. I don't know. I don't recall hearing that it was cited after that, but it has not played a role very much. I don't think it ever decided a case. Maybe even somebody puts it into a footnote, but that's not quite the same thing. So a danger of the Bill of Rights always was that, and I don't know if this was specifically pointed out back then, that, the theory of the Constitution, I have a revisionist view, but I mean the general theory of it, and certainly the libertarian and conservative theory of it, is that it's a document that defines a small number of powers to the Congress, and that it can only do what's mentioned, right? You can only exercise enumerated powers. I don't believe this is right, but that's the story. And so if the government wants to exercise a power, anybody's entitled to say, hey, where does it say in the Constitution that you can exercise that power? Okay, that's the way they say it was supposed to work.
Right.
Which, if it was, that's not too bad, right? At least it puts the burden of proof on the person asserting a power. And you'd either have to say, well, it's right there, or it's implied by this power that's right there, something like that. But the burden's on you if you say it's got this power. What some people believe that the Bill of Rights would do would be to shift, and I think it's happened that way, to shift the focus. Now, if somebody asserts a right, the Bork types, the Scalia types would say, where does this in the Bill of Rights? Where's that in the Bill of Rights? So see how they turned it on its head? Instead of saying where's the power enumerated, it's where's the right enumerated. And that puts now the burden on the person claiming freedom. That's not the way I thought it was supposed to work.
This sounds a little tangential and maybe like law makes me sound law illiterate, but that sort of, to me, comes back to the fact that, and I've thought this before, that the simple concepts of a negative and a positive liberty are some of the most important concepts, philosophical concepts that you could possibly have. I mean, you need a basis for that, I suppose. You need your natural rights, or your self-evident, what you call it, or you need God, or whatever you so choose. But that, to me, is so much more substantial than a constitution, even one that tried to bind its own hands a little bit. Because it doesn't matter, you either have the right to be free from something, you do not have the right to something, at least, without some sort of free exchange with another person. I mean, it's so damn simple. I realize this is like the easiest libertarian lesson in the world, but that solves these things to me, But of course, it can't be that easy for the powerful people, because that's no fun.
Right. Well, and I've written recently 2 articles just in the last month or so called the Constitution Revisited and the Bill of Rights Revisited, where I show that that's actually not what was going on. That's not what the framers had in mind, certainly not what Madison and Hamilton had in mind. They did not think the Bill of Rights was anything revolutionary. It was rather a conservative invocation of the quote, the rights of Englishmen, right, the ancient rights of Englishmen, right, that they believed were non-controversial and that would not occasion any argument. They added them because people demanded a Bill of Rights. And so Madison had promised that he'd add amendments. Everyone else was willing to say, hey, once the Constitution was ratified, the hell with what we promised people. We promised them a Bill of Rights, but too bad, it's ratified now. Madison, a man of honor, and also Jefferson had a huge influence on him. He said, I promised that I'm going to stick to my promise. So he was about the only one who then, when he got into Congress, which wasn't easy for him because he couldn't get either of the Senate seats from Virginia, the Virginia legislature, and it was the legislatures that picked the senators in those days.
Oh yeah.
Until the 17th Amendment, right during the Progressive era under Wilson, the Virginia legislature wanted to put in 2 anti-federalists, and they didn't like Madison. He was a nationalist, and they wanted 2 anti-federalists, so they put in I forget, Richard Henry Lee, I think, and I can't remember who it is. James Monroe, maybe? No, James Monroe ran against. So Madison then has to run for Congress. He has to run for the lower house. He couldn't get into the upper house, and he runs against James Monroe, who's also an anti-federalist, and he wins. He manages to win by a few votes. So he decides that he's going to keep his promise, and so he sorts through like 200 amendments which had been recommended by the ratifying conventions.
Wow.
People at the ratifying conventions they didn't make their ratification conditional, but they said, hey, we want these amendments attached. So there were 200 of them. Most of them would have changed the structure of the government as outlined in the Constitution, so Madison immediately threw those out. He wasn't going to consider those. And what was left were basically what we ended up with. Anyway, that's getting us, I think, probably off on a tangent.
I don't know, I was learning. It was fun, I was learning. Stuff I don't remember or didn't know in the first place, so that was good.
Well, it was interesting. So they reported out 12 amendments, but only 10 made it. 2 didn't make it. 1 had to do with apportionment for Congress, and 1 would have forbade congressmen from voting their own pay increases.
Oh, that would have been...
forbidding it. Those amendments didn't get through the ratification process in the states from the state legislatures, but the rest did, and so that's where we get the first through the 10th Amendment. But they weren't regarded that controversial, and the anti-federalists who made a mistake in demanding a Bill of Rights when they really had more serious objections got fooled, because they gave them the Bill of Rights, and then they said, this isn't what we really wanted anyway. So it's, when you can't take yes for an answer, it looks bad for your position, doesn't it? So the rest of their objections got basically tossed out, and the Federalists, including even Hamilton, was in the end glad there was a Bill of Rights because it kind of shut up the anti-Federalists. He was happy about that.
Yeah, I mean, if you write down your laws, there's always the limit in them. I mean, I'm reminded of Radley Balko's Rise of the Warrior Cop book. Has some good sort of pre-now stuff, and he makes he makes the fairly serious argument that in Britain, pre-Revolutionary War Britain, in some ways, the Fourth Amendment was stronger. Rather, the castle doctrine, the English common law, man comes his castle thing, was actually stronger several hundred years ago than it is today, which is a very disturbing thought. He certainly argues it well, but once you write it down, then there are the people who can look at each word, and this is literally their job, and say, well, it doesn't protect against this. I mean, because of course they mean this. And Scalia was better on the Fourth Amendment than I would expect his type to be, but the Supreme Court in general in the past several decades has been pretty horrible on it. And to me, it's always feels like there's this, these people think that, securing your papers means just literal papers. There's this there's this completely limited idea where, well, it's different with a phone or an email or third-party doctrine, or you gave your records to here, so they're not protected, or you're on the border, so you're not protected. I mean, once it's written there in all of its limiting language, people are there to poke holes in it and to thereby violate your privacy, of course.
Yeah. So I don't think Scalia, I mean, I can't say this for sure, and as you pointed out, Scalia was good on some of these types of issues. Like, he dissented, I think he was on the losing side of this, he dissented on the case that said where cops were taking DNA for anybody arrested, they were swabbing the inside of people's mouths. He was against that. He thought that violated the Fourth Amendment.
He was good on, he agreed.
He was good on a lot of stuff like that because look, the Fourth Amendment is in the Bill of Rights. So from a Scalia point of view, it does say there's got to be reasonable cause and probable cause, and you got to have a warrant, and people are supposed to be safe from unreasonable searches. And he wouldn't say, well, it says paper. I don't believe he'd say, well, if it says papers, they literally mean papers.
Right. That's more a mentality that
maybe I'm wrong about this, but I don't believe he'd say, well, they didn't say cell phones. I mean, I think that's a caricature of that position. It's it's more sophisticated than that. We don't want to make a straw man. We want to take their strongest case. But here's where I think there's a problem with this. I mean, there's more than one, but here's where there's a problem with this textualism, this idea of textualism. And Roderick Long has written about this. If we the current generations understand, say, the concept of justice differently from how the framers or the people generally people back then understood that term, just because our understanding has over time increased and we now realize that something is unjust that maybe people back then thought was just, are we supposed to be stuck with their narrow, now revealed as a mistaken concept of justice, or are we supposed to say if they said justice, then we're entitled to make it justice as we understand justice? So I agree with Roderick about that. If we're going to play the Constitution game, why are we stuck with their definition?
Well, because even I would argue that there's a lot of people in the world who would make the Constitution worse today. I mean, I'm mocking originalism, at least as I interpret it, but God knows the living Constitution people are, at least as bad, probably worse. The idea of the slim Constitution and Bill of Rights, that it's all about what the government can't do, as opposed to the EU style, here's the Constitution, here are your rights,
Well, I don't know if
it could get worse.
I don't know why that's worse. Scalia, thought Roe, he wasn't on the court, Roe was wrongly decided. He was on the wrong side of Lawrence v. Texas, which the state outlawed homosexual sodomy. There's a whole line of cases. I already mentioned Obergefell. Why is that worse than what progressives or living Constitution types would do? I think it's a draw, which is a good reason to be an anarchist.
There you go. Podcast over. No, that's just a perfect. Yeah.
No, there is a problem with constitutionalism that way, and that's part of it. And I don't know who's worse. I mean, look. Okay, so bring it to what's going on right now. Should Obama get the pick, or should the next president, who may be a Republican, get the pick? What do we think would be the best outcome as libertarians? I'm not really sure. I mean, I don't know if I'll prefer the Democrats' nominee to the Republicans' nominee. It's not automatic. They're not necessarily good on economic freedom, the Republicans.
Right, and obviously, even if a Democrat or Republican to us is good half the time, that's a pleasant surprise. And on the Supreme Court in particular, again, there's always this mixture. I mean, many of the so-called liberal justices that I can name, a lot of them were pretty wretched on what we would consider social freedoms for years and years. Scalia was, of course, atrocious on gay rights and pleasantly fair to good on the Fourth Amendment, which is not something we expect from a right-winger. The Supreme Court is a very, I almost think it's particularly silly to try to predict what a justice would do, because it's such a bizarre position for your whole life or until you retire or die. I mean, that's a hell of a
we can find
thing.
many, many examples. Look, Trump has been going after Cruz. Why? Because Cruz defended the nomination of John Roberts. Roberts twice upheld, was the deciding vote upholding the Affordable Care Act.
Yeah, that's right.
Harry Blackmun, who was put on by Nixon, wrote Roe.
I didn't know that.
You can name case after case. Eisenhower and the Republicans were very disturbed by what Earl Warren was doing on, desegregation of schools and stuff like that, because they thought it interfered with the states. There's lots of examples. That's true. To go a little bit deeper with Scalia, because I think it's worth. This is an important point for libertarians. There's a great classic essay, which Lucy, I'm sure you're familiar with, or you've read, from the early 19th century by Benjamin Constant, who was a Paris-based. I don't think he was actually born in France, but classical liberal, friend of Bastiat, hung out with that crowd, right? And he wrote this great essay, which you can find online, called "The Liberty of the Ancients Compared with the Liberty of the Moderns." So he was contrasting these two notions of liberty. And so the Greek notion, the ancient notion of liberty, was being able to participate, right, in the democratic process of your city-state, getting to be involved in the argument, right, the debate over public policy, getting to cast your vote. But once the vote was cast, then you were obligated to go along with whatever the outcome was. But that was considered liberty, and you even see this in Rousseau, right? You could be forced to be free, which means forced to abide by the general will. Freedom just meant being part of that process. The liberty of the moderns, according to Constant, was not that narrow view of participation. No, he thought democratic participation was an element, although a minor element, of freedom. The real freedom for Constant, and libertarians will nod their heads at this, is personal autonomy.
Right.
Being able to do what you want with your life, with your property, as Constant puts it, even destroying your property. And I don't know if he used the word privacy, but obviously that would be implied. So these are two stark differences in the notion of freedom. And as I point out in the article, I put the link up there. Scalia was in the ancient school. He was not a man of the Enlightenment, because his view was freedom was being able to participate. When the Supreme Court struck down those laws in the states that would not recognize same-sex marriage, he said something like, what bothers me about this ruling, he says, I don't care about same-sex marriage. Let's take him at his word. He probably did. He was a Catholic, but let's just assume that he's right about that. He says, what matters to me is the process. He says, it's of overwhelming importance, however, who it is that rules me. Today's decree says that my ruler and the ruler of 300 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. What did he prefer? He preferred that we be ruled by the 320 million Americans, of which I'm only one. So what chance do I have? So he thinks self-government was shut down when a majority of the 9 said you couldn't have those laws. And he thinks that violated the freedom of self-government, because for self-government for him meant this collective governing, the right operation of the democratic process. Not self-government like the advocates of self-government mean it, but self-government, the big self, not the micro self, the macro self versus the micro self.
And to me, that's often, I see that as such a liberal argument. And again, the evil, scary right-winger, but a lot of liberals, very, very mainstream, I'm talking, sort of straight and narrow liberals, make that very similar argument. It's all about, what all of us are voting on. Though they do tend to like their judicial activism when it helps out with their causes, which they should. I mean, we should cheer. The process, I realize it can always backfire horribly, but I always think whatever the hell the process was, no matter who was conferring or checking what box, the end result was freedom. I'm gonna accept it. That makes me not a constitutionalist, that's for sure.
Right. Both sides are, at least some of the time, small d Democrats. And here's Scalia being a small d Democrat, right? He's saying, and he wants broad scope for this democratic, what he would consider democratic self-governance, except when it comes to, the strict enumeration in the amendments 1 through 8 actually, since 9 doesn't matter. And of course he would care about the 10th, but that's about powers, not rights. So 1 through 8, and then the couple of the prohibitions, right, in the Constitution itself, like the states can't impair the obligations of contracts and things like that, right? There are some prohibitions on power in the Constitution itself, mainly the states, right? It's Article 1, Section 10, I think. So he's a Democrat otherwise. Otherwise, where the Constitution is silent, as he would see it, again, forgetting the Ninth Amendment, the people, as a collective body, should be free to make those decisions. And if the courts step in, he said when the court stepped in on Obergefell, he said it ended the same-sex marriage debate, and as he put it, a display of American democracy at its best. So here's the court, 5 members of the court stepped in and thwarted democracy. And we would say as individualists, but what about the individuals who wanted to live as married couples and have that recognition? I mean, we may not put, as libertarians, we say, what the heck, the state shouldn't be involved in marriage. True. So maybe we don't put any weight on this idea of recognition.
Hospitals,
not everybody's a libertarian.
Yeah.
So they do want that sort of, to them that's their public declaration. And doing it through just a private contract to them wouldn't have the same meaning. And besides, a lot of the states that didn't allow same-sex marriage also didn't recognize private marriage contracts.
Right.
So you couldn't just say, well, let them have a private marriage contract, because they weren't enforceable in those states. And you're right. You named other things like being next of kin and being able to have some rights regarding a terminal patient. Where a family might say, I don't want my dying child's homosexual partner allowed in the room, even though they may be living as a married couple, and the person in the coma would have wanted that. I mean, There's all those kinds of things. I mean, that were thwarted by these laws. And what about so those people are just supposed to wait until they can convince a majority of the people in the democratic process? Why is that fair?
Well, the strange thing is, I've never actually read directly the essay you referenced, but I've certainly encountered these arguments. But I'm thinking back to my college days and some of the debates that were had, and I'm realizing how many people were arguing a pre-Enlightenment perspective on freedom, which, to sum it up that way, it seems it's very interesting to me, because I hadn't been thinking of it in those terms. But that is what everyone who says, well, vote on it. Well, we should vote on it, or if you don't like it, run for office. And like so many other things in left and right, in the mainstream sense, they start to, they come back to each other in the end, and they're all about the process is the argument. We have to do this the right way, and it never comes down to human freedom being the highest priority. It's pretty low on the list most of the time. I respect
freedom is the freedom to participate.
Right,
which is Rousseau's idea.
Right.
And why do we want to embrace Rousseau? I'm not sure the founding fathers. If you want to, I don't like to talk about the founding fathers. I hate that phrase. It makes demigods of them. But the framers, and those early guys, and I don't think they embraced Rousseau.
Right. It's one of those things like the labor theory of value, where I feel like it got diffused and snuck into a lot of people's heads without them really knowing it. They sort of subscribe to these ideas without realizing it. I don't know.
Yeah, and there's I can recall a lecture that Scalia gave, I saw it on TV or on YouTube or something like that, and in a Q&A, I forget the exact issue that someone was raising in a Q&A, but his answer was, go get a law passed.
That's what progressives say all the time when I yell about stuff. I mean, everybody in my damn college, that's all they would say when you would argue with them. And my God.
That's not the job of the courts, he'd say. That's not the job. Now, I heard him say, Piers Morgan, I didn't realize this, a few years ago, 2012, I think, Piers Morgan, who I'm not a fan of, he'd be very obnoxious, especially with people who believe you ought to be able to own guns. But he interviewed Scalia, and CNN was showing excerpts after the news broke about Scalia's death. And so Scalia, he's a very engaging person. He's funny. He's obviously a very bright guy. But he said something like, look, I don't like the consequences of every decision I make. That's not my job. And I said, I do sleep well at night because my job is not to come up with what I like. Or I guess you'd even say of what I think is just. My job is to interpret the Constitution according to what I already said, right? According to how those words are understood back in the day, and also interpret statutes, laws, by the intent of the legislators, or what the words mean today. But he said it doesn't mean I like what I decide. But so that leads to an interesting sort of question. If you're doing should you take a job where you may have to commit an injustice or facilitate an injustice by making this decision? It seems to me you'd have to say, yeah, there are unjust outcomes to what I do, but I can't help it. I didn't write the Constitution. My job's not to rewrite it.
I mean, that's why I have absolutely no sympathy for various judges who are like, oh, I feel bad that I have to send this, third-time weed dealer to jail for 30 years under mandatory minimums, but it's my job. I'm sorry, but your job is to quit your fucking job.
Yeah, isn't that like I'm following orders?
I mean, Nuremberg. Yeah, it always tends to go back to the Nuremberg defense, and yeah. I think
that's your temper. I think our respect for Scalia, because at one level you may say, yeah, I disagree with the guy, but I have to admire him. He's intelligent. I have to respect him. But you add this to it, and I think it does subtract from that.
It does. I don't want, by virtue of a segue, to suggest that Congressman Justin Amash is a Nazi, because I'm also trying to get an interview with him. But I will say that he, either last year or the year before at the big Students for Liberty conference, to paraphrase him, he basically said, I think that I have to vote on what I think the Constitution says, not on my libertarian heart of heart and like what I would want to happen. So I mean, that's a similar sentiment to Scalia. I think Amash is less dangerous and less powerful, obviously, than Scalia was. And I think his impulses are certainly more Enlightenment, based, which is an improvement. But there's still an element. These people who are in these positions, they have to go with what they believe the Constitution says, not what they think is the best outcome. So,
well, Paine and Jefferson and some of the the more radical people at the founding believe that we shouldn't be ruled by the dead hand of the past. Mm-hmm. Right? It was one of their arguments against monarchy and and the whole system that they were rebelling against. But it seems to me that would lead to this view that I attributed to Roderick Long, that if we realize that the framers misunderstood, say, the concept of justice, and it actually includes things that they excluded, why are we stuck with their understanding of justice if we understand it better?
Because we'll turn into Europe, I guess.
Wouldn't the dead hand of the past be ruling if we say, well, that's how they understood it?
I mean, in a sense, we're not entirely constrained. Because our Constitution and Bill of Rights, especially, they're small enough. And again, this is a theoretical argument for a binding Constitution that actually works better than ours ended up working. But I can see the theoretical arguments for this as clear as anything, where you don't want to turn into Europe, where you have a positive right to everything. You want, the America of theory, which for a nation state sounds all right, where you have a very limited government. And, I'm trying to argue something that doesn't work, because it hasn't worked and it didn't work, but it was a nice idea, I guess.
There's dangers on all sides. Yeah. And so this is a good segue. I know we're running out of time. We can go, well, I guess we can't go a little over. There's probably something else coming up afterwards. But, so I'll quickly plug a book that's relevant to this whole discussion. It's a fairly new book It's Jacob Levy's book, Rationalism, Pluralism, and Freedom. Or is it Liberty? I have the book here somewhere. Liberty, I guess, is the word in the title. Really very good book. A tour de force. Covers a lot of history of thought, and sociology and political theory. And the idea is that there are two strains within liberalism, and always has been. And by liberalism, he's using it very broadly now. It certainly includes libertarianism, classical liberalism, might also include so-called, modern liberalism. But here are the two strains. The one is what he calls rationalism, and by that term he means, and you can see this in Paine and Voltaire, that what we need is a unified system, that an overarching body of law. They weren't anarchists, so they would mean a state that enforced liberal law for everybody in a country, everybody, and there were no intermediate institutions, right? There's no essential federalism or private organizations that can interfere with this, because private organizations, my gosh, can be oppressive. I mean, look what they do to Amish people, or look what Muslim families do when they make girls wear headscarves. I mean, you can come up with lots of examples, which are not crazy examples. You see this in John Stuart Mill. John Stuart Mill was as much concerned about the tyranny, maybe more so, the tyranny of society as he was with the tyranny of the state. And he thought the further away the state is, the better. So he'd rather have one overarching national government than lots of centers of not just power in the sense of coercion, but authority. Then, okay, that's one strain. That's the rationalist strain. He calls that rationalism. You may call it centralism. But the other is pluralism. The pluralism strain, which you find in Tocqueville and Montesquieu, is that no, you want a multitude of all kinds of groups, private, towns, states in the United States, existing alongside the central state, the central system. So you want that hubbub and that conflict, because that protects liberty from the individual. All those layers are buffers, right? You got the central state, but then you got all these buffering organizations, and at the bottom you got the individual. That protects liberty. So both of these are represented in liberalism, each arguing that my system protects liberty better than your system. And what Jacob argues is that there's validity in those arguments. However, both sides have also ignored the danger in their own preferred system.
Right.
So local groups can be oppressive, and central states, as Jacob points out, are not impersonal dispensers of justice. They do lots of bad things. They don't just protect you from your family, your church, your private association, whatever it is, ready to jump in when there's an injustice. They find all kinds of reasons to jump in for public choice reasons. So there are these two irreconcilable, he says irreconcilable strands. There's no way. So it ends up being, as I put it, by the way, my review of his book will be in the next issue of the American Conservative. I can throw out that plug. Somebody once said, basically, this was an exact quote, but the price of liberty is eternal vigilance. That's the answer. Because you can't assume that setting up one or another set of institutions will safeguard, and then will be on automatic pilot, and liberty will be safe. You can't assume that.
Right.
No matter which of the strains you side with, pluralism or rationalism, you can never just say, okay, we got it right, I'm going home and going to bed, I don't need to watch this anymore. No, we always need to watch it.
But that, of course, when one wants to avoid bloody revolution on humanitarian grounds, there's also that problem where you don't want to refresh the tree of liberty with the blood of various tyrants. So, hence it being sort of lose-lose, but also an inspiring eternal struggle, whichever one you feel like describing it as.
Anyway, your turn.
Well, we could go a little over. I mean, it's not like there's someone literally waiting behind us, I suppose. But I don't know. But I am not caffeinated enough to keep up with your historical and constitutional knowledge. I mean, I'm not hopeless on this, but man, you're a higher weight class on this one than I am. Which is...
Well, I've been, I'm collecting my Constitution writings into a single volume. So I've been writing essays. Going on 10 years now. I mean, I started doing this. My constitutional revisionism. I started writing at FEE in 2006. So, and I've written a few lately, like the two I mentioned, the Constitution Revisited and the Bill of Rights Revisited. So I thought, okay, it's time to put them together. It'll be a thin book, but that's good because it means it's not intimidating. It'll be accessible to anybody. It's not going to have a footnotes or, you know, citing court cases. It's not that kind of book. So the title is The Constitution Revisited: A Libertarian Look at America's Counter-Revolution, which kind of gives it away. I stole part of the title from my friend Jeff Hummel, who has an essay you can find online. It was published by the Libertarian Alliance in the UK some years ago, called America's Counter-Revolution, a tribute to the Anti-Federalists. And he drawing on a lot of very good historians. Gordon Wood is one person I draw on a lot, and also Merrill Jensen, point out that the Constitution indeed was a counter-revolution. The American Revolution was a radical revolution. They both say that. But the purpose of the Constitutional Convention was to rein in the radicalism, and downgrade the states, create a real central government which had its own power to tax and regulate trade. Let's remember the central quasi-government that existed before that under the Articles of Confederation could not tax. How can libertarians talk nice about the Constitution? The Constitution, this is a slight oversimplification, the Constitution was a tax program. How can libertarians embrace it? It's not a landmark in the struggle for liberty. It was a setback.
Articles of Confederation or bust. That doesn't mean
the articles were perfect. As Jeff Hummel says, the articles created much too much of a central government for his. But by comparison, if you put the Constitution in its historical context, which means the articles came before it, then it doesn't look so good. And what Wood shows, and my article quotes the people he quotes, so he's not just spinning this off, he's drawing on the people that who were active at the time. What they were trying to do was they thought things were too democratic, too egalitarian in the states. Now, they had some valid arguments because the state legislatures were being used to gain economic benefits at the expense of other people. For example, helping debtors at the expense of creditors by trying to get money printed and stuff like that, and other kinds of debt relief. So the criticism was right that, hey, you guys are using the state legislatures as like auction houses, basically. That's wrong. But their answer, we would say, as a libertarian, I'd say their answer was wrong. Their answer was, we need to make sure the hoi polloi don't get into power.
Right.
So let's move things up to a higher level of centralization and weed out the common man, so that only the gentlemen of leisure, who are disinterested and neutral,
of course.
Yeah, that's what they said, can be in power, and you folks who have to make your living day to day in the marketplace and therefore are skewed or have very skewed views of your interests and what the national interest is, we'll filter your views through us, and that's where the protection of liberty will come. That was their view.
Yeah.
Why does any libertarian embrace that? And I don't mean this. That's not the same question as why aren't you an anarchist?
It's a related topic.
It's related. I would say. But you could still hold on to. I was going to say theism. You could still hold on to minarchism, and say, yeah, the Constitution wasn't good after all. So it's not strictly that. You could. I don't know what answer you'd come up with, but it's still a minimal government person could say, yeah, I agree with you about the Constitution. They needed to do something else. So it doesn't automatically make the leap to anarchism.
Well, I mean, there are a couple of minarchists like Jacob Hornberger and Eric Garris who are so close that I don't think, they're not strict constitutionalists. Emily's like, they're almost there. So I think maybe they could, make the argument you say. I will say that my final push into anarchism was the 1-2 punch of Anthony. You helped start it off, I will say, but Anthony Gregory's 2 speeches back in 2010, one about war, war, the health of the state, the worst government program there is, etc. And one where he just meticulously went through, I think, just the Bill of Rights and pointed out how terrible and vague and just not good a lot of things were, even like eminent domain, just compensation. What the hell does just compensation mean? Subjectivity. Just little sort of tiny little just pokes, and somehow it worked. It was very effective. So
these speeches. Where did he give these speeches?
I was an independent institute student event thing. Yeah. But it was a good. I always wish those were recorded somewhere because I would like to see them because they're now historical in my life.
No, he's definitely good. Well, the story is very different from the story we all learn as children, but then that too many libertarians seem to carry on. Hummel calls them constitutional fetishists.
Yeah, there's a lot of those. And
they don't want to let go of it, and it's this idea that the reason they put together the reason the Constitution's purpose was to limit the national government and protect the states and individual liberty, but that just does not line up with the history. As Madison and James Wilson, who was a very important figure in this push for a constitution, were heading to Philadelphia, they both say, look, the complaint is not that there's too much government, the complaint that there's too little government.
Yeah.
And the idea that the Constitution was primarily needed to create a free trade zone, which is something you often hear, that the states were putting up trade barriers against each other, and therefore the great thing about the Constitution was it created a free trade zone, is false. That's erroneous too, because you have Hamilton in the Federalist Papers, I think 75 or one of the ones in the 70s, says something like, look, if we adopt the Constitution, we could triple the tariff.
Mm.
So that gives the game away. It wasn't to create a free trade zone.
Plus, they gave us the magical power of the Commerce Clause, of course.
And the states, by the way, I should add, right, the states were not erecting trade barriers against one another, as Hummel argues or shows that you had an occasional trade barrier to a European good that went from one state to another. So let's say, for example, New Jersey might say that if a good comes from Europe to New Jersey, and then a merchant wants to bring it into New York, they would put a duty on that. But it was because it was European. I'm not justifying it, but it wasn't against New Jersey, manufacturing. And so there weren't state barriers to each other's products. There was an open free trade zone. So the Constitution couldn't have been for that reason. I think the Commerce Clause was essentially a mercantilist clause. Do you need to plug any shows?
Oh, well, on Thursday, I'm actually going to do my Politics for People Who Hate Politics show. And I'm going to have Will, the horrible conservative who's fun to yell at, from Unbiased American on, and my friend Todd Seavey, and a few other fine folk. We're going to talk about, among other things, my friend Andrew Carell's look at is there a libertarian case for Bernie Sanders article. So we'll be talking about things along those lines on Thursday at 10 Eastern. So y'all can pop in if you want, if you care about that at all.
Excellent.
My throat is very dry. And what was that?
Oh, okay. I said Andrew Carell is a good guy.
Yeah, I'm always hoping to get him actually on more. He was on my show once. He's good people.
Well, we should also take up some week this question about Bernie Sanders, because it's quite polarizing. When I put up, you responded. When I put up what looked like an endorsement.
Do you want to come on? Come on the show.
Yeah, but then you have a lot of voices. Don't you want to keep it more simple? You want all these voices?
My Thursday show is the panel show. I mean, you and I have this, and the one-on-one is very good. But the rowdy panel can be a lot of fun, and even if the audience, has more trouble, it's fun to be on such a show. So consider that an open invitation. You can defend your Facebooking.
More and more people are writing about how bad Bernie Sanders' foreign policy record is. But even with all that, I still have the sense that he's the least bad. Because you got to go pretty far to lose that spot with those guys.
You do.
And with those guys and that woman that he's running against.
I'll send you an invitation for Thursday in case you want to pop by and defend your Facebooking.
That's good.
I don't have a link offhand I would send to the chat people, but I've been to tout myself. Well, or I can tout you. That's how we usually do this. You being at antiwar.com now, and Reason Still, and your free association blog, and this podcast, and your Patreon, I believe. All those things.
Yes, you become a patron of Free Association through Patreon, or you can do it through PayPal too. I have the links up there. I'm on Liberty.me, Media with Conscience. Reason, except Reason did not publish my satire from last week, where I broke the story that Obama was suspending TV network coverage of U.S. wars in the Middle East because it tended to radicalize, or at least had the danger of radicalizing homegrown lone wolf terrorists. So he was shutting down coverage. Some people didn't catch that was satire. Some people got very mad at me. So, and I noticed that Reason didn't use it. They usually run that my Friday article on Sunday, and I don't see it up there.
Maybe satire opens up too many questions, and I don't know.
Maybe that was too deadpan. I thought I gave it away when I had the candidates reacting to this, and I said Kasich reacted, but nobody can remember what he said. It should have been a dead giveaway that was satire.
One would
and
think.
I closed it with Rubio saying, look, we have to get over this notion that President Obama doesn't know what he's doing. He knows very well what he's doing.
I still love when that happened. I really thought my DVR was malfunctioning. That's how similar. His first repetition was exactly the same phrasing as it had been 2 minutes before, and it really, if Mitt Romney can never escape the robot reputation, I feel like Rubio, just based on that, should be sunk because it's just too easy. But he'll recover. He's already kind of recovered, unfortunately.
Yeah.
Neocon.
I don't even know what point he was trying to make by that. So it was a total non sequitur. Anyway.
I think the idea is that not that Obama's incompetent, but he has a terrifying agenda. He's a politician. Of course, he has an agenda. I think that was the idea. It's
supposed to be related to his lack of experience because they say it about Rubio. So Rubio wants to say, "Hey, that wasn't the problem with Obama."
There's also that. Yeah, good point.
But even that's not really responsive because you can have no experience and still do what you think you want to do, right? It's not just. Right. I mean, so it doesn't really answer the point.
I mean, they're portraying Obama as like hitting government buttons. I don't know what to do, and he's saying, "Oh, he knows what he's doing."
Yeah, but does anybody claim that he's just like in a panic?
I don't know. Maybe.
What do you do in this room? I don't understand what all these levers.
Yeah.
I don't think that's the charge against Obama.
That's what I assume government.
No one denies he had an agenda.
Yeah. Well,
they just said he was inexperienced and he had a bad agenda. That's the criticism.
Well, of course, he makes the argument, as all politicians do, that when he legislates, it's somehow like apolitical. But if you protest, like, let's not make this political. Everything political is not political if you're the one doing it. That's a neat rule of politics.
Okay, well, should we wind this down?
We should.
I hope we answered all the questions, although we ignored if there were any questions, I guess we ignored them. I don't see any questions.
I didn't see any, no. I have to tell the good people that they should read my work at Playboy, which I've started writing political stuff there.
So this is a regular gig now?
I don't want to jinx myself, but for the short term, it's like a regular contributing thing. So it's good.
Nice spot.
It is good. I wish I had a link, but I don't have one at the moment because it's a little hard to get to Playboy due to its history of being less clothed. But I have lots of political things there, and I just did a Trump one, why Trump is the worst, and tomorrow it's why Hillary is the worst. It's actually going to be a series all week long where I talk about how each candidate is the worst, and it's a beautiful gig for me. It's very appropriate.
So I can find these aren't gated?
No, they're not gated. The Trump one is on my Twitter, which is Lucy Stagg, LucyStag, people.
Yep.
So it's out there, and I put it on Facebook.
Next time you see Hef, say hi for me.
I'll just go. I'm going to go party at the mansion now, which is why we have to wrap this up.
I understand the mansion's for sale,
Well, I don't think I have quite enough nickels to scrape together to buy
Although
it.
it's for sale, but the sale is going to have a condition that he gets to live there until he dies.
Well, that's fair enough, I suppose.
I heard that on CNN.
No, fair enough.
It's only the $2 million or something. No, $200 million.
They've always had good articles. I mean, that joke is a joke, you know, reading it for the articles, but it was always true. It really was. They have a lot more literary clout.
Oh yeah. Hey, Carl Hess. Carl Hess had a great article in Playboy. What was it, 1967 or something? It got the award. You know, they do awards at the end of the year. Best nonfiction. It's The Death of Politics. Look it up. You can find it online. It's a great
They're
article.
famous for interviews and such. Alvin
Toffler interviewed Ayn Rand.
I know, that's why that joke is weird, because it's not really a joke reading it for the articles. I mean, I know there was that other bonus factor, but it's not a very good joke because the articles were always good. Anyway, read that, and antiwar.com also. And I guess I have other things, but those are too far away on the road, so I'll brag about them later. All right.
Well, everybody else, have a good fortnight. We'll be back.
This was good, and I feel like not in your weight class with history and constitutional stuff, but it was fun, and I'll brush up, I swear. It was good to talk to you.
You can read my forthcoming book.
Yes, I'm going to read your forthcoming book. I'll do it. All right.
All right. See ya.
See you around.
Bye-bye.
Bye.